very impromptu. So it's probably going to take a while for people to catch up. Let's get some settings organized first, which I kind of should have done before I hit the play button. Let's do that. Let me add that. I'll change that around to something like that. All right. Hey Shelby, thanks for joining me. You're all alone right now. Actually, tell anyone I was going to go live. So hey Kim, hey Guano, and hey Batman, and Tiff. Hello. So I'm really curious about a couple of things here. How does this judge handle, her case with Brian? It's another murder case. Hi, Susan. And also, what's going on with the Proctor stuff in this case? So, yeah, we're all tied up with the... Hey, Laurie. Thanks for joining us. Shush. I mentioned you on Maz's show about your latest video on Sean. Yes. Interesting. Well, hopefully I gave you all... It's a secret. I hope I gave you all enough time to watch that video before I hit the live button. Hi, James, and hello, Joyful. Hello. So, are we all curious about this? Because I certainly am. And I know we were all very busy watching TV's hearing today. The two killer bees going at it. That was a bit of fun, wasn't it? Hello, Anne. They're not calling for the prosecution, you reckon? I don't see how they don't either, but we had this same quandary with Karen's case, right? We were like, what happens if they don't call him? Like, what impact does that have on the jury, right? I love the nicknames you guys come up with. Give me Sean McDonut. McDonut. I don't know who you are usually, but I like whatever the handle is that you've got right now. I'm sure I should know who you are, but anyway. Let's have a look at... hang on, I want to go... Whoa. Oh my God, I don't know what I'm doing, guys. Let's just go. Let's just go.
I'm going to go through what I have on my agenda, and then I'll address with you whatever, if I can, address with you whatever.
Can you hear it?
Questions you have. On my agenda today is to talk about the pending discovery.
I do need to know if you can hear it.
See if we can make some forward progress on that today, either today in the hearing.
Because I have my headphones in today.
In the near future, I want to discuss the scheduling order and where I see this case going in terms of progressing forward and discuss your joint.
Do you guys hear it? Yep, you can hear it. Cool. That's right. Bradle and Betteray had a good day, even though they didn't release all of his devices. Well, Kim, they actually released the data from his devices. So that's almost as good as getting the devices back, I reckon. Shari, thanks for joining us. I found you today. And also, do you want to be a mod? Really, the only difference is how the questioning goes. If defense calls him, they can't treat him as a hostile witness. I guess it, yeah. I guess it depends if he becomes hostile on the stand or not. I don't know, really. All right, so you guys can hear it. All right, so yeah, me too, James. Howdy doody. It's crazy, right? I don't know. I just know it's like I think it's just it's a thumb drive that he got back, but I don't know. I think it's from all of his devices. I'm not sure. CPU mod, hello. All right, Shari D. I'll add ya. I'll add ya. And Shelby, I'll add you too if you want the power. Who wants the power? All right. Yes, Troll Patrol. I don't have enough mods for the different times of the day, so yeah, happy to add you guys. All right, let's hit the play button. So I'm probably going to stop it a lot and like read your questions
Motion
and
that
stuff.
we submitted last week and the preview for that.
Okay.
I guess I don't see this case going into 2026 for a trial. I think it should be tried in 2025. I'm certainly going to do my part to make sure that it keeps on track to get us there. And that's due to, in large part, the age of the case and its respective complexity, or not, and the range of cases like it. So I think that it's reasonable to assume that a case such as this one will be tried within 2 years from indictment. On the present schedule we're looking there that you suggested, I think it's coming closer to the 3-year mark, and I think that's a little unnecessary. And nothing gets better with time. People's memories don't get any better, and the case isn't going to get any stronger. People's memories fade over time, and so I've been interested in making sure the case gets tried as efficiently as is possible, respecting the numerous issues that have to be addressed. So we'll talk about that. And then I think attenuate to the motions that have been filed, we're going to need another date, or perhaps need another date on the Rule 17 motions, which I appreciate the defense filed to come up, I assume, based on your earlier pleadings, and third parties may be filing objections to those, so we'll get that on the calendar. With regard to the calendar, I'm happy to come down here today. As you know, I have been specially assigned. I want you to know when we're picking dates for future things that it's highly likely you're going to be traveling. I'll try to travel here when I can, because I know that this is where it is. But you should also build in the expectation that you may be traveling, and the travel in the next 3 months is going to be to Middlesex County, because that's where I'm going to be assigned for the first quarter. Deliberately not far from here, recognizing that I probably would be seeing you a bit between now and whenever we get the case ready for tee up for trial. So let me say that, just so that you sort of have an idea of what my knowledge base is, and I've gone back and tried to listen to a number of the hearings on the case, most notably, I guess most importantly, your last hearing before Judge Cannoni, when this issue with regard to, I think as Attorney Tipton said, it was an exhaustive or extensive discovery request came up, and you all thought that you could make some headway, and you did make some headway, although there's some disputes that still linger. At that time, so I listened to that last hearing. I also went back and listened to a hearing on June 24th, in which we were first, the parties informed the court that the trial date was too tentative at that point.
How are we going, guys? Sounds good? We got a good on the sound check. And is my image okay today? Like, apparently I was failing really bad at this the other day for the images. So, how are we doing with that? So we've got hi Lorena. Anybody? Yay. Kevin the Sally Port camera. Welcome. Miss Jessica, you're now a mod. Shari D and Shelby, I don't remember who wasn't mods before, but it's all got a wrench now. Tracy, thanks for joining us. Karen, thank you for modding for us tonight, Karen. It is tonight there, right? It's this morning here still. Thank you, Laura Jean, for the super chat. Much appreciated. And I do what I do for you. Hey, Mac Dickles. Indeed, Canoni baloney. Okay, all's good. Picture's good. Sounds good. All right. Glaring cupcake. Total Rider. Oh my gosh, you're going to have to add mate to that. Thanks for joining us. This is how exactly Mark. And hello, Mark, and thanks for joining us. Nancy. All right, my lady. Goldfish. Yay. How's my picture today, Goldfish? All right, we have an army of mods tonight. Yes. Yay. Has Ozzy had any sleep in the... I think I had a nana nap, Shari. After Turtle Boys caught, I had a nana nap, and then I got this brainwave, like putting those two pieces together with the court thing, because I realized when I heard Bradle say it that I actually hadn't mentioned that part of it yet. So, yeah, there's no sleeping when I get a brainwave. It don't happen. Anyway, let's go on. Let's hear what she's got to say.
I have before me now what are the first round of discovery disputes. Those were docketed, just for the record, and as paper number 18, the defendant's motion for discovery of documents related to the district attorney and law enforcement. That then gets updated by your second motion, which I got to be filed on Friday. That's paper number 32.
Happy to oblige, Nancy.
I've gone through the Commonwealth's oppositions to those. And then also, I received on Friday paper number 31, which is,
Tippy.
I'll call it the federal investigation motion, and the Commonwealth's opposition to that, which I just briefly, I got it just as I was coming down the stairways, and I read it, but I haven't given it much thought. The first thing I wrote before I got here, opposition was do a TUI request. And so I see that at the end of that, that's exactly what we're doing. We'll get to that in a minute. So I've read all the pleadings. I have looked at some of the law that I want to look at. There's one thing that I didn't get a chance to look at this morning, but I'll hear from you. And perhaps the best way to do it is to just go item by item and identify. I think it pretty clearly now identifies where there's a variance. If you wish to be heard on any of the orally, I'll certainly give you the opportunity to do that now. If you want to rest on the paper, so that's fine too. I may have questions as we go through them.
Do you all recognize the prosecutor?
Paper number 32 and go through those now. Sure.
I think by and large, I'll just rely on
This was today, Karen.
that we filed after the Commonwealth and the defense sat down on a number of occasions and worked through
Hey,
this.
Laura.
By and large, Judge, what we're asking Just turning to page 2, paragraph 1, subparagraph A.
Yes.
We continue to ask for disclosure. I understand the reality of this is that they've engaged an attorney who I am familiar with professionally, and like I say in our motion, we don't object to Attorney Sack being assigned to review. So we have no objection to him, and I'm not familiar with Jim Carney, but I have no objection to Jim Carney. It's just that we believe, based on the existing case law and the citations that I've provided in the memorandum, that
I missed the
defense
fan,
counsel
Kevin.
is in the best position to assess the exculpatory nature and the utility of this information, whether it impacts bias, credibility, or the Bowden defense of the conduct of the investigation. And for those reasons, and I'll leave it at that, we ask that this material that the Commonwealth declines to turn over be turned over.
Did you say the
Other than
Odin defense?
that's all I'd have to say on that particular issue.
Comment?
So, Your Honor, I can tell you that not only did we retain Attorney Sack, and he's received the download of the phone.
Oh, good, Shelby.
I am also going through the phone, through all of the emails and all of the text messages and anything that could be a statement to try and find Brady material. But I'm also focusing in on Rule 14 statements, and I feel it's my duty under Graham and McFarland to go through this myself and find anything that could be potential bias, but also statements, and I'm doing that. I've focused in on all
I'm happy to hear that, because you'll find that I try to be as transparent as I can to both sides. And when I read this,
Hang on. Wait, hold that transparency thought. Kim, try going to the top of the chat and choosing, what is it called? Change your chat setting. I forget what it's called because I'm looking at the restream chat. You should, I think it's from top chat to all chat or something like that. You might see everyone then. Okay, so who's this woman here? That's Lally's sidekick. And now Lally's the sidekick, but that's Michelle, what's her name? I've forgotten her freaking name. I've forgotten her name for some reason, but I know her first name's Michelle, isn't it? But anyway, that is Jim, I think. Jim the court dude. Jim the basement dude. Yes, I think it's all messages or something like that. Live chat. I forget. I know there's another setting there that you can switch it to, and that'll probably show you more. Thanks, Shari. Scooby's mom. Hello. Yeah, there's a whole bunch of other cases happening. McLaughlin. Yes. Laura. Okay, I thought it was Michelle. But it's because her last name's McLaughlin and I was thinking Michelle. You're just going to be in my brain. It fits, all right? And to answer your question before, Karen, Cole, it was a good day for Turtle Boy. We thought it was actually going to be a bad day because the judge was like cranky as. But then he sort of gave them everything that they asked for. So it was a good day. Yes, I do too, Tiff. It's weird. But, you know, YouTube is just weird anyway. Everything's weird. All right, let's listen to the transparency the judge is going to offer him.
I don't know Attorney Sachs, and I don't know the computer person either, but this is interesting. The Commonwealth gets to delegate its responsibility to review the materials. The defense isn't objecting to it, but I have never seen special ADAs special prosecutors assigned to a case, but I've never seen a third party that's responsible for that. And my initial response, honestly, was, I don't think they can do that. I don't think they can delegate that responsibility to an attorney. It sounds like you've got belt and suspenders. You're doing it yourself, and it's a backstop or a double check.
Yes, Your Honor.
For the consultant attorney.
That's the purpose of attorney staff. It's not to outsource it, but to double check what the Commonwealth has done.
Okay.
And he's-
Murdered his wife, Melissa.
All right. That's always good to have another set of eyes, I suppose.
Yes, Your Honor.
All right. Anything else that you want to talk about with regard to this beyond what's in there?
All right, Brian Walsh, I got to pause it to tell you. Brian Walsh murdered his wife, and Proctor was one of the lead investigators. And all the stories, like Sean McDonough telling us that Proctor got properly fired, came from his defense attorneys, Walsh's defense attorneys. They actually submitted a motion saying, "Yep, he's fired," but it wasn't true. It was the defense attorneys had been misinformed. And then Sean got it weeks after we all found out that it wasn't true. And then he's like back to like, my sources. It's like, dude, we know what your source is. Your source is these lawyers, and they were wrong. That's right. It's one of those. Another one that got thrown into turmoil because of Proctor's texts in the Karen Reid trial. So that's right, James. It does. So, okay.
Not beyond what's in the papers, Your Honor. We pointed out that there's sensitive material in there about ongoing investigations. Turn over the phone to Walshe would be problematic. It could jeopardize ongoing investigations, and as a result, that's one of the key issues of why we can't turn over the phone to Walshe.
He's saying he can't turn over the
What I'm going to do
phone.
is, following this hearing, is I'm going to give you an omnibus order on discovery. I'm going to follow your, sort of how you set up the issues, because it makes sense. And so I'll just go one, A, B, C, it makes sense. And I'll probably be doing that more quicker than I thought it was going to be, because my trial was supposed to start tomorrow, just 10 times.
He said we can't turn over the phone.
Look at this. While it's fresh in my mind, I'll get something out to you. I will tell you that preliminary view on this is that it's the Commonwealth's obligation, and that nothing that has happened or that I've read so far turns that on its head. And the idea here that I understand that the defense has a very unique perspective on every piece of evidence that is just a different view than the prosecutor in the case is going to have. But in some ways, I feel like you're inviting me to rewrite the obligations of Rule 14, and I'm not prepared to do that right now based on the information. that I
Type
know.
something, Kevin.
But that's just my preliminary view, and I want to give some more thought to the arguments. All right?
May I proceed? Are we done?
Yes, please.
With regards to paragraph number 2, the request regarding the 3074 pages, I will defer to Attorney Kelly Porges, who at the time we finish this motion, she will be arguing the motion that addresses that request, I think.
Okay, that's the motion paper number 31.
Yes.
I'll defer on that one.
We don't need to touch upon paragraph 3. We're waiting for production of those letters. Paragraph 4, we don't need to address, because we're withdrawing that at this time.
All right.
What's your withdrawing?
Regarding
I gotta stop. Hang on a second. Guys. First of all, the Commonwealth just said they can't hand his devices back. We just been told all freaking month that he got his devices back like the same day. And the Commonwealth just said they can't give his device back, his phone back, because it's oops, I hit the wrong button, because it's an ongoing investigation. So there's that. Secondly, Laurie, it's midday here. It's actually midday here, not midnight. I do need more coffee, so I'm going to let this run for a little bit. Laura, you caught one. Yeah, I'm confused too, Melissa. Because the Commonwealth just said, hang on, I'm going to have to rewind it. Look, let me go back, because I'm pretty sure that's what they just said. Let's go back to...
preliminary view on this is it's the Commonwealth's obligation, and that nothing that is doing that more quickly than I thought it was going to be. My trial was supposed to start to set up the issues because it makes sense, and so I'll just go one.
Listen to him again.
It makes sense, and I'll probably be doing that more quickly than I thought it was going to be. My trial was supposed to start tomorrow, just tanked on me, so I'll have an opportunity to look at this. While it's fresh in my mind, I'll get something out to you. I will tell you that
That might be a bit too loud.
my review on this is it's the Commonwealth's obligation, and that nothing that has happened or that I've read so far turns that on its head. And the idea here that I understand that the defense has a very unique perspective on every piece of evidence that is just a different view than the prosecutor in the case is going to have. But in some ways, I feel like you're inviting me to rewrite the obligations of Rule 14, and I'm not prepared to do that right now based on the information that I have. But that's just my preliminary view, and I want to give some more thought to the arguments that have been made. All right?
May I proceed? Are you done?
Yes, please.
With regards to paragraph number 2, the request regarding the 37 to 40 pages, I will defer to Attorney Kelly Porges, who at the time
I
we
missed
finish
it.
this motion, she will be arguing.
Stop. Where is he saying?
As I can, both sides. And when I read this, I thought this is interesting. The Commonwealth gets to delegate its responsibility to review the materials. The defense isn't objecting to it. But I have seen special ADAs, special prosecutors assigned to a case, but I've never seen a third party that's responsible for that. And my initial response, honestly, was, I don't think they can do that. I don't think they can delegate that responsibility to an attorney. It sounds like you've got belt and suspenders. You're doing it yourself, and it's a backstop or a double check.
Yes, Your Honor.
For the consultant attorney.
That's the purpose of attorney staff.
All
It's
right.
not to outsource it, but to double check what the Commonwealth has done.
Okay.
And he's doing it independently.
All right. That's always good to have another set of eyes, I suppose.
Yes, Your Honor.
All right. Anything else that you want to talk about with regard to this beyond what's in the papers?
Not beyond what's in the papers, Your Honor. We pointed out that there's sensitive material in there about ongoing investigations. Turn over the phone wholesale would be problematic and could jeopardize ongoing investigations. And as a result, that's one of the key issues of why we can't turn over the phone wholesale.
He is saying turn over the phone. That's why we can't turn over the phone. So he's saying it's an ongoing investigation. That's why we can't turn over the phone. So they've still got his phone.
By the way, what I'm probably going to do is following this hearing is I'm going to give you an omnibus order on discovery. And I'm going to follow your sort of how you set up the issues because it makes sense. And so I'll just go one, A, B, C. It makes sense. And I'll probably be doing that more quickly than I thought it was going to be because my trial was supposed to start tomorrow, just tanked on me. So I'll have an opportunity to look at this. While it's fresh in my mind, I'll get something out to you. I will tell you that
That's a good point.
preliminary view on this is it's the Commonwealth's obligation, and that nothing that has happened or that I've read so far turns that on its head. And the idea here that I understand that the defense has a very unique perspective on every piece of evidence that is just a different view than the prosecutor in the case is going to have. But in some ways, I feel like you're inviting me to rewrite the obligations of Rule 14, and I'm not prepared to do that right now based on the information that I have.
Rule 14,
But
it is
that's
Proctor's
just my
phone.
preliminary view, and I want to give some more thought to the arguments.
You're right, my lady.
All right?
May I proceed? Are you done?
Yes, please.
With regards to paragraph number 2, the request regarding the 37 to 4 pages, I will defer to Attorney Kelly Porges, who at the time when we finish this motion, she will be arguing the motion that addresses that request, I think.
Okay, that's the motion paper number 31.
Yes.
I'll defer on that one.
We don't need to touch upon paragraph 3. We're waiting for production of those letters.
shit.
Paragraph 4, we don't need to address because we're withdrawing that at this time.
All right.
Sorry.
Regarding-
I just knocked something. I'm making a coffee now, guys. I'm AFK, so you just listen for a bit.
Paragraph 6 is really subsumed in Rule 17, and we'll deal with it.
5 is not an issue either, right?
5 is not an issue. I'm sorry. And once again, paragraph 7, that's assumed in the Rule 17 request, I do believe. Number 8, we all agree, at least the Commonwealth and we agree that that's captured in paragraph number 5, the request 5, and we'll need to deal with it. Moving ahead through now to request number 14. What we're trying to do is say that, argue that the Commonwealth needs to produce this unless it can make a sufficient showing of what it characterizes as the basis of its argument, that what we're asking for implicates the work product rule. And where I would agree that if the work product rule under 14A5 is in fact implicated, I understand that they would have grounds to say they can't disclose it. But I find it hard to believe that what we're asking for, that the entire universe is captured as work product. And so for those reasons, we ask that that request be allowed in so much as what we've asked for, that they
Why
have not
isn't a
agreed.
good initial step to just say, have them, we commonly see this in civil litigation, but go through, but it's perfectly appropriate for criminal litigation as well, to go through and say, this is the basis for the work, this is, the privilege law, and at least give the defense then the universe of what the responsive documents are, and if it is the Commonwealth's position that they're covered by work product privilege, there'll be enough information that you can make everybody can make some preliminary assessments. And if there are some that still can't get to yes and figure it out through that long, I may then entertain looking at them myself, but I don't think that that's necessary as a first step. What's the Commonwealth's view with regard to privilege law?
Your Honor, there are some items that would be distinctly privileged that we would have the burden to show. That being said, the Commonwealth is producing any and all notes written by any of the officers, investigators in this case.
I saw that.
In reaching out to, we've also produced any and all notes and reports from the crime lab. I'm reaching out to OCME to see if they have any additional notes. So the only notes that I can think of that aren't being produced would be mine. And and my notes would be on scheduling, strategy, theories, thoughts on the case. And so at this point in time, those would be worked on.
All right. Do you have any objection to putting those in a log?
I would, yes, Your Honor. I
Why?
would. Well, because
I mean, all I'm asking you is from the date, if you have it on your notes. If it's an internal note to yourself, that's it. Internal note, 88 Connor. Date. I'm not asking you what's in there. You can say
it's just
you can
not
say
how-
as blandly as trial strategy, if that's what it is.
Well, my notes might not reflect dates so much as where I am sitting at my desk writing down theories. So the best I could do would be to say.
I'm not asking for that, Attorney Tipton, right? You don't want to.
So I will go through my notes and see if there is anything that would be discoverable under Rule 14. But as of right now, I can't think of anything, but I will double check, and if it gets to the point that I have to create a log, I will. But I will see if there's anything that contains a statement under 14.
All right, if there's any, if this is a series of notes, it seems like an exercise in futility for you to have them do the log. I'm just saying if there's something more complicated or complex than that, because I'm clearly not giving, you don't want them, and you're not going to get them. So if it's something more than your notes, something going back and forth that reveals strategy, perhaps with you and the investigators, I'm not going to have you produce that either. But he wants a record, and he's having Attorney Tipton's, credibly saying that he doesn't think that that's the whole universe of what would be out there. It may be.
And so, Your Honor, if we're talking about communications, separate from notes, like I said, I'm going through the emails and text messages that are in the phone. And if there is anything in there that's discoverable under Rule 14 as far as a statement of a witness, that's going to be turned over.
Sure.
I intend to be as liberal as possible.
She's given him more stick than Bev gives bloody the Commonwealth, isn't she? Like she's drilling him about his note. She's drilling him about production. So, we didn't hear Bev drilling anyone about production.
Understanding what could be 14, but if there is something in there that is trial strategy, and I think that it could get to that point, we're talking about statements in the phone, then I would create a law.
Okay.
I would create a law, because that it seems like the appropriate way. If we're talking about the phone itself, but when I say the phone, I'm talking about Michael Proctor's work phone.
Right.
I'm not looking to go through every person's phone. I have no knowledge of what is in every other person's phone. But Mr. Proctor's phone is distinctly in the custody and control right now, or the download of it of the district attorney's office.
Okay.
Bingo! It's Proctor's phone. So, well done, my lady, for guessing that one. You're smart. Thank you for the super sticker, Joseph. Much appreciated. For sure, Nancy. For sure. Yes, Kim, this judge seems to be doing a job proper. So they just had to put, a-holes. Hello, Librarian. Libra. LA Libra in Seattle. It took me a minute. So it's Proctor's phone. So he was trying not to say that, right? He was doing his best, like he was like, I'm a lot of real quiet before. That's why we had to listen to it twice. Hey, Bob. Hello, my crime. All right, well, yes. I don't know why Karen doesn't get the fair judge, because it's not a fair trial. Probably.
All right. So with regard to that, let me finish by saying, any notes, and you'll see this in the omnibus order, any notes that are internal notes to the prosecutor, I don't need to see that on the privilege log. If you want to revisit that, Attorney Tipton will let me know. If there's something that comes up in the course of your review of the phone that is of the sort, I know it varies a little bit off of what we're talking about right now in this particular request, start making a privilege log.
Yes, sir.
And honestly share it as it's being updated.
Yes, Your Honor.
Okay? All right.
Focusing our attention on both paragraphs 15 and 16, I think I can just argue these both together.
Sure.
And the gist of this is our request is because the Commonwealth has said they are not in possession of anything and any knowledge at this point, my subparagraph F Really what we're asking for then is to make sure that the Commonwealth, in an affirmative fashion,
Yes, Sue.
requests cellular records and text records of the Cohasset police that would impact and bear upon bias, credibility, or the investigation. And I say that because without
Promise
an
not to
inquiry
call you
by
that.
the Commonwealth of its agents, that being the Cohasset police, we really have no way of seeking this type of information. But more important than that, that given what we now know about what has and may have occurred within the ranks of the Mass State Police assigned to the District Attorney's Office. And I'll just add, without trying to sound hyperbolic about it, but in the Boston Globe today, there was yet another report talking about the failings, if you will, of the Mass State Police in the way it disciplines its officers, and the way that certain officers, at least one, was promoted even after significant complaints were made. I think to fulfill McFarland and Graham and the requirement of Mass Rule Criminal Procedure 14A3, that the Commonwealth should be required to inquire specifically whether the Cohasset police have checked, and I'm not talking about all the police officers, I'm talking about the Cohasset police, and there's 3 primary officers involved in the investigation of Mr. Walshe, to see if they have anything that comports with, and who knows if they would disclose it, but I would hope they would, comports with text messages and emails and cellular phone records that indicate a bias, a prejudice, and a lack of professional integrity when it comes to investigating Mr. Walshe. And I will say that it was the Cohasset police, and I'm not casting aspersions on the Cohasset police. I'm just saying that if it's out there, the only way to really get to the bottom of it is if the Commonwealth fulfills its duty of inquiry and then returns back and tells us. I leave it at that.
Who are the 3 Cohasset police officers you speak of?
Yes, do tell.
Schmidt, Lopes, and the third name is eluding me right now.
That's him there, guys. That's Walshe.
Can you come on when you want
Well,
to sit on the third name? Or
I would suggest that Harrison Schmidt and Anthony Lopes were the lead investigators for the Cohasset Police Department. Several Cohasset police officers did aid and help. So there, if you were to say that there was like a B team that was helping with the initial investigation, that would be more than just those 2 officers. But Lieutenant Lopes went to Washington, D.C. and did some investigation, and Sergeant Schmidt has been the case officer for the Cohasset Police Department. So, Your Honor, as far as a duty to inquire, I am happy to inquire of the Cohasset Police and the state police investigators to see if there are any statements in text messages or emails that fall under 14 or are exculpatory, for instance, under Brady, McFarland, and Grant. I'm prepared to do that. That being said, cellular records is a bit more of a problem because I don't think a cellular record, whether it be a call detail record, would necessarily show anything. It would show maybe a call takes place, but I can't tell you that that call is about the Walshe matter.
And well, and that's what I wrote in my notes next to C is, how would a telephone record tell you whether it related to this case or not?
Let me just apologize for being unclear about that. I should have been much more specific. I really wasn't looking for phone logs or anything. I was looking for something that was contained on their cellular phones, such as, whether it be emails or text messages, or the written word that would be indicative of bias and credibility issues. I am not interested in, at this point, of looking at phone logs, and I apologize for not being more clear about that.
So with that, I would inquire of the officers.
All right, we have a record.
Yes, Your Honor.
Yeah, it's a bit lackluster, Kevin, isn't it? Oh, hopefully Hopefully that's a Channel 10 problem and not a me problem. Hey, it's V Dot. Dude, I don't know what's going on with the stream. It's brokered. Alright. Come on. What the hell's wrong with you?
I'm looking at phone logs, and I apologize for that. Something a lot more stern than in their possession was destroyed or altered, and they would tell us that. I've
There
been
you
working
go.
with this DA's office for
It
2
just needed a
decades.
little shove.
So when I read that this morning in preparing, I cringed because it suggests that they're unaware of their own mistakes. And
That's how I read it.
What I was trying to say was, when they respond that they're unaware of anything being destroyed or altered, at least by their office, I take that at their word, and I understand that. So what we're saying, though, is, once again, a duty of inquiry, and a very specific inquiry of its agents to find out if anyone else is aware of something being lost, destroyed, or altered by way of, whatever that is, if it has to do with the investigation of Mr. Walsh. And I think a duty of inquiry is required under the facts and circumstances, and what history has told us now, the recent history of the conduct of some officers involved in the investigation of this case. And so that's really what we're asking for, just an inquiry at this stage to make sure that there is an affirmative statement on the record that after inquiry.
Okay, wait a second. Is my internet crappy again today? Are you getting a bad picture? I'd have thought Goldfish should have been crying at me by now. If there's something he can't stand, it's a shitty picture. Was there a fart? I don't know what you're talking about. It might have been just me moving stuff around here. So, I don't know. I didn't hear a fart, and I got headphones on. Not advisable, I agree. Okay, Kimberly says hers is fine. Sean McDonough says no. I don't know what no means. Picture is good. Okay. Right. Yeah, the buffering was... So the other day it was just blur. It was blurry and not moving in time with the sound. So as long as that's not happening, then we're good. Okay. Yeah. Right, Shari. You've seen the issues we've had in the past. So cool.
There's no knowledge of anything being altered, destroyed, or corrupted.
Okay.
I appreciate Mr. Tipton, his honesty on paragraph G, because I was confused as well. Because when it comes down to it, is at this point in time, I don't know if something is lost or destroyed. So if I find out, that would be exculpatory, and under the rules, I would have to tell him. So I would tell him. I guess what Mr. Tipton is asking me to do is to actively go and ask every officer if anything is lost or destroyed. When I do my inquiry, I will ask if anything is lost or destroyed.
Sounds reasonable. Okay.
I think that's what's the
That was faster than I thought.
Well, get a grip, cameraman.
All right.
We just
Do we
about
want
went
to
up his
address,
left nostril.
Paper 31 and whatever the column has been docketed as the next entry, which is the, I'll call it the 2-8 enforcement. Now that the defense has seen what the column intends to do, is that, I mean, that seems to me the way that we get the information, if they're going to get the information.
Respectfully, Your Honor, they have the information. The information is in the custody of the Norfolk County District Attorney's Office, so not only is TUI unnecessary, it would still be premature when you look at the cases such as Donahue and Lehman.
What if I'm not persuaded by your argument that I ought to be persuaded by this Rahim case, which I frankly am not persuaded by?
So the first question is whether or not the documents are under the purview of Rule 14. We believe they are. We're kind of at a disadvantage because, one, we don't have a copy of the protective order or the...
Okay, she just said TUI. Why are they getting a TUI? I mean, she said a TUI is not necessary, but this is confusing because the TUI motion is like what the feds did in Karen's case, where they found, exculpatory evidence in their investigation. And then the TUI process is how they hand it into a criminal court process. Like the feds are obviously federal, whereas this is a state criminal trial. So they can't actually interfere with a state criminal trial. So they go through the TUI process to be able to enter that evidence into the trial. But why is she talking about TUI in this case? Because I don't believe Walshe has any feds involved in his case.
non-disclosure agreement. So we're at a loss there because I can't specifically articulate what exactly the protective order is, what exactly...
Stop it.
Is that if it is physically in their custody, then they have received it. It is in their control. They possess it. Just because a federal agency says, no, it's really ours, it's not theirs to give.
That was very much so in the context of a joint investigation, right?
It was, Your Honor, but in this case, the government, the federal government and the Norfolk County District Attorney's Office were
Well, you
essentially
could be
working
right,
together.
lady.
They were working to investigate a homicide that Norfolk was prosecuting. They were investigating the state police for integrity violations, policy violations, inappropriate conduct, failure to supervise. And so this information has been starting to get turned over to us, and as Mr. Tipton articulated, whether it comes to Bowden or credibility or bias, that's part of what we want to show and we
Tip's
expect to show. So we believe the material is Rule 14. They have it, ergo we should get it. So I don't think TUI is even necessary yet. If they've indicated they're going to take that road, then that's fine, but that does not negate our argument that it is Rule 14. And the SJC as recent as 2020 has clearly stated that it is in their possession. With respect to the cases they cited in their response, they're relying on Commonwealth versus Bonnet, which was a 2015 case. I don't believe that's on point.
Totally makes sense that they're against it because it's going to be prejudicial for their clients. So I think you're exactly right. It's the artwork, but I don't see what the artwork has to do with the murder unless it all happened around the same time, I think. I don't know. We haven't got the details on that yet, have we? Did he do the fraudulent artwork first and then he killed her, or was it all around the same time as part of killing her? See, it might be tied to her murder directly. So, but I get why the defense is saying they don't want it.
Bonnet is a case in which the state district attorney's office was not aware of the identity of a confidential informant. And so it wasn't in their custody. And secondly, they were saying that it was privileged. We have nothing to show that anything in those 3,074 pages are privileged or protected. We don't know. We've pulled it together from pleadings from other cases, responses from the government, just to know that they have it, roughly what it's about, and then several letters between the district attorney's office and the federal government talking about this material, specifically the officers involved.
Ah, that's right.
And the
You're
reason
right,
I
Libra.
can point to, there's a myriad of reasons why it would be relevant, but what we're able to determine is
Yeah.
that Trooper Proctor, who was the lead investigator on this case, the moment he stepped foot into investigating Brian Walshe and the disappearance of his wife, he knew he was under federal investigation. And so his bias, his motive, anything or his integrity is forefront for him. So with all those thoughts, when you're considering all of that, I don't know how it's not Rule 14. I don't know how we're not already in possession of this. And so otherwise I rest on the papers. And they talk about Beal, your argument. In Beal, I agree the prosecutor doesn't have a duty to go investigate our case, but they haven't. So we're not asking them to go get something they don't have. And in footnote 4 in Beal, which is cited in their brief, it specifically says the government isn't able to simply put their head in the sand if there is something exculpatory. And documents that show that the lead investigator in a homicide case knew he was under federal investigation the moment he stepped foot in the case is certainly...
Isn't it even stronger? Well, I'm not making your argument, but wasn't he already under prosecution?
No, Your Honor. Do you mean
So
Mr.
what's the
Walsh, or do you
yes.
mean no.
What's the timing of his federal indictment?
Do you mean do you mean Trooper Proctor or Mr. Walsh?
I thought you were talking about Mr. Walsh.
No,
that
Mr.
there's a
Walsh
bias
is
because
state
he knew that
investigation.
Mr.
No, Trooper Proctor knew he was under federal investigation.
federal investigation.
The moment he
I thought you were
stepped
saying
foot.
there was a bias against your client
No.
because he was under
No.
federal eye.
No, it's Trooper Proctor.
That's an additional bias, by the way.
Right.
See, at least we weren't the only ones who were confused here. So she's talking about Trooper Proctor's federal investigation. I think she's moved on to that one. And then she mentioned a confidential informant, which I'm not really sure what that's about. I'm going to have to read some of these documents because there's a lot of stuff going on here. There's a lot of moving parts in this story. He got 80 grand selling 2 fake Andy Warhols in 2016. So he was already under house arrest when he murdered her. Right. Yeah, exactly, Taryn. What would you do it for? Oh my God, Shari, it's so good that we're not the only ones getting confused. So, if she's talking about the TUI process and she's talking about Proctor, all right, do we need to rewind a bit? I think we kind of do. Let's just go back a bit.
The moment he stepped foot in the case is certainly...
Isn't it even stronger? Well, I'm not making your argument, but wasn't he already under prosecution?
We're not already in possession of this. And so otherwise I rest on the papers. And they talk about Beal, your argument. In Beal, I agree the prosecutor doesn't have a duty to go investigate our case, but they haven't. So we're not asking them to go get something they don't have. And in footnote 4 in Beal, which is cited in their brief, it specifically says the government isn't able to simply put their head in the sand if there is something exculpatory. And documents that show that the lead investigator in a homicide case knew he was under federal investigation the moment he stepped foot in the case is certainly...
Isn't it even stronger? Well, I'm not making your argument, but wasn't he already under prosecution?
Okay, now it makes sense.
No, Your Honor. Do you mean
So
Mr.
what's the
Walsh, or do you
yes.
mean... No.
What's the timing of his federal indictment?
Do you mean do you mean Trooper Proctor or Mr. Walsh?
I thought you were talking about Mr. Walsh.
No,
that
Mr.
there's a
Walsh
bias
is
because he
state
knew that
investigation.
Mr.
No, Trooper Proctor knew he was under federal investigation.
federal investigation.
The moment he
I thought you were
stepped
saying there was a bias against your client
No.
because he was under
No.
the federal line.
No, it's Trooper Proctor.
That's an additional bias, by the way.
Right, but we're just focused on that part. At the moment he stepped into this investigation, and bear in mind, the Norfolk County District Attorney's Office, they control homicide investigations.
Glenn!
They work with the state police, with CPAC. So now, the Norfolk County District Attorney's Office knew that Proctor was under federal investigation, specifically for how he investigates supervision, etc. He now
Prince!
is the case officer in this matter while his case is pending. So that's one of the myriad reasons why not only are these documents relevant, they could very well be exculpatory. And under Rule 14, it's not exculpatory, it's material and relevant. And so with respect to that, I would rest on the papers, Your Honor.
All right.
So, Your Honor, it's my understanding that the federal government has never said that they were investigating officers. That's never been a public statement by the U.S. Attorney's Office in this matter. They have released information to the Karen Reed prosecutors that was subject to a federal protective order signed by a judge that is impounded that I can't see. I have also not seen the materials that were turned over to the Karen Reed prosecution team. So I don't know what's in those materials either. I can tell you that I watched a large portion of the Karen Reed trial, and from what I could see, 2 witnesses identified that they had testified in a federal grand jury in that case, when they were testifying in the state Karen Reed trial. It's further my understanding that the federal government acknowledged that they were investigating the death of John O'Keefe, not the district attorney's office and not the state police. It's also my understanding that the U.S. Attorney's Office has not said that this investigation...
You bloody thing. Let's go again.
A state trooper, the district attorney's office, Canton Police Department, any civilian witnesses. I have received no knowledge of anyone receiving a target warning. And I would suggest that this is premature, that I have filed a TUI request with the U.S. Attorney's Office for the Walshe materials. I told counsel today I think I should file a TUI request for...
Oh my god, why is it doing this? It's just a bad stream.
I can understand if they want to do their own, but that would be my suggestion, because I would suggest under ALEA, we have a...
Oh my god. You suck, YouTube. 36.
a federal non-disclosure. So I'm not...
Let's press the pause and let it catch up. Alright, where are we? Yeah, exactly, Thomas. Oh my god. Well, who was expecting Karen Reed's name to come up in this trial? I mean, we were always expecting Proctor, but I get what he's saying. He's saying she said, well, they already have this information, so, you know, Proctor's text and rah, rah, rah. The Commonwealth does have that. But he's arguing he can't look at the TUI documents in Karen Reed's trial. He's arguing a completely different thing. Yeah, this is like, it's a red herring. In as far as logical fallacy goes, that's a red herring. Like, he's not arguing what she was arguing. He's arguing something completely different. So you watch, the judge is going to tell him, yeah, but what about Proctor's text, because they're not part of the TUI.
I'm not prepared to have someone from my office be charged with contempt. I would prefer that we go down the road of trying to work with the U.S. Attorney's Office and see what those results are, report back to the court, and let the court know.
All right. I'll take a look at the cases.
No,
that
he
both sides
did,
have
Colleen.
cited, and I'll include whatever.
She did, sorry.
Regarding to that in the omnibus order as well.
And one last point, I don't think we can say that the U.S. Attorney's Office and the state police work together on this investigation in the matter of John O'Keefe. it looks like it has been completely two different agencies doing two different investigations. I don't see any, there's been no sharing of information until there was discovery turned over at the Karen Reed trial.
Well, Your
Thanks
Honor,
for
it's
the
not-
super sticker,
the case
Jason.
law isn't just about specifically whether or not they worked on this case together, but if there is cooperation in general between the two agencies, which clearly there is. And the problem is, there's too much we don't know, we think. I don't think it's, respectfully to Mr. Connor, I understand he's willing to make the TUI request, but I don't know how we say we're going to make a TUI request, which when you send a letter to the U.S. Attorney's Office saying we believe you have relevant material information, and then at the same time object to the Rule 14 of materials in their custody. That's no foreign deal on point. You can't put your head in the sand. I don't think it's right to be like, well, someone else in my office knows, but I'm just not going to talk to them about it. I understand if there's protective orders and if the government wants to rely on that at this point, but I think that not only is there evidence that these two agencies routinely do work together, I think the fact that the officers involved in both cases were under investigation for whether it's integrity, investigation, failure to supervise, I think that does count as working together through this case as well.
I would just disagree with that.
All right.
If I may, Judge, just briefly, I don't want to step on anybody's toes here, but when Mr. Connors just said that we didn't want to work with him, I will say we will work with him. I just don't want, and Attorney Porges don't want, that our efforts to work with the Commonwealth dilutes our Rule 14 argument. That's all.
Don't dilute the 14. Do anything else, but don't dilute the 14.
We get the lower hanging fruit, the Rule 17, when do you want to schedule that?
I reached out to Chief Legal Counsel for the state police. They asked for 4 weeks.
Okay?
So with
What does that bring us to?
4 weeks would bring us to the beginning of January, first week of January specifically. January 6th through the 10th.
I'm available.
All right, so, I want to get a date on the calendar, and recognizing you're likely going to be up in Woburn for that one.
That's right.
And so I just want you to know that in advance. I'm happy to do what I typically do, and frankly, what I'll be doing when we try this case or whatever that is. I try cases from 9 to 4.
Oh, thank you, Libra.
And what I do to accommodate the other business, depending on the length of the case, is try to go on the bench at 1:45 and clear away the more straightforward matters, and frankly put off the more substantial matters to a time when you're not on trial. And the goal there is to keep the case moving and to be as most respectful, frankly, as I can to the jurors who are making a big commitment of their personal time. So it becomes a little bit of a juggling act, but it's doable. You just do it for the 2 weeks. This feels like a 2 to 3 week trial for me. You're going to tell me later on down the line what it really is, but just on the limited knowledge I know, 9 to 4, Monday through Friday, it feels like 2 weeks, but I don't know enough about the science yet.
We're anticipating 4 weeks, and
On a full day schedule?
on a full day schedule.
Scotty, master of multitasking today, dude. Mammoth effort. You were in the chats, you were modding, you were out there holding a sign, you were in front of the camera. Dude, you had it all going on. You did better than me today with the multitasking thing. So, I think, Kevin, I think they're trying to exclude Proctor's testimony, maybe, or evidence. I don't know about evidence. Probably both, actually, when you think about it. But I'm not sure. I'm not entirely sure what they're arguing. Just like right now, they just after all his info. Don't know what they're going to do with it, but that's what they're asking for, just all of his informations. But I do remember something about Morrissey. Morrissey said he's not going to hand over the text because it would be Proctor's text to this defense, because it would be too invasive on his privacy or some bullshit. I can't remember what it was exactly. Yeah, I'm not really sure what the defense is going to do with it once they've got it all, but right now this is just getting it so they can determine, I guess, what they're going to do with it.
We were just talking about that before we came.
You're probably right. It doesn't feel that way to me, but that's only because you know a lot more about the case than I do.
We also know each other. We've done a lot of things with each other as far as trial work, and we know that neither one of us kind of wastes each other's time, so we just believe that we're probably in that realm. We also think that impanelment will take 5 years.
And that my estimate was after we get the impanelment, which could be 1.
Yours after.
I was trying to include impanelment, so I think that if you're thinking about testimony, it's probably about 3 weeks.
So it feels like.
Yeah.
Jim's doing a
But
bobblehead.
again, your estimates, I'm going to take your estimates to the bank because I'm just entering the case and you know so much more than I do about what it's going to take to try the case.
Yes, sure.
So, but that's important, and it's a good segue. Anyway, let's get to, the reason I mentioned that scheduling issue is I can see you at 9 o'clock in the morning if you want to do that, and I'll just delay my trial on that day till 9:30 or 10 if that works.
Maybe.
You don't like that, and I get that because you're going to have to deal with the 120 in traffic going up there, which is not good. I could see you at 1:45, and I'll give you 1:45 to 2:15.
Indeed,
Or I can see
Scotty.
you at the end of the day. Pick your time slot.
Whatever works for Mr. Dickerman, happy to do it.
145 certainly works for me.
All right, let's do the 1:45.
Which day?
Indeed, Phoebe.
Any day but Wednesday or Thursday or Friday that week would be best because the panel on the case alone is probably going to take a couple of days.
How about January 9th, which is the Thursday?
That's the one date I couldn't do that. Sorry.
So I picked it. How about the 8th?
January.
January the 8th.
At 1:45 in
Wednesday?
Wednesday.
Yes. And if the defendant wants to be there, obviously we can get him there. If you want to waive his presence for that, that's fine too. You just let the court clerk know. You're on trial, given the nature of this dispute, also seeing you on Zoom. So, given the nature of it, the dispute, I don't know that we all have to be physically in the same room. I prefer that, but it certainly isn't necessary.
Get on with it.
All right?
I think
So-
they're just booking hearings now.
Let me move to the schedule. Let me see if I can find proposed
Scheduling.
schedule.
Put your butts on the like button.
Every judge has pet peeves. We all do. You do too. Your own pet peeves or your practice. One of my pet peeves is serial motions to suppress. I like to do them all at once. I never understood why you have a motion to suppress this, that, and the other thing. Just do it all together. Evidentiary, non-evidentiary, put it all together. So I want one date for the motions to suppress.
Oh my God, I love this
Or
judge.
all into, break it out if you want to break it out. But it's all going to be argued and heard on the same day. And so that's going to compress the schedule. The other question that I had about, and these are just
Yeah,
general
this ain't Auntie
observations,
Bev's
I looked
room,
at your
guys.
There's a sort of relatively brief period of time, as you have it scheduled right now, between the motion to dismiss and the motion to suppress. So in my judge mind, I read one of two things. They don't think one is really coming and it's not going to change the schedule. Or there is one coming and obviously we're setting ourselves up for, we're not going to even get to the April date. So those are the thoughts that are running through my head. This case ought to try in 2025. I think we should pick a trial date in around a year from now. Now that you're telling me it's 4 weeks, I'm much more likely to look to November as opposed to So when I was driving down here, I thought, first week of December, we'll get this in before the end of the year. We might. Maybe somebody could take a look at the calendar and see when Thanksgiving is. Maybe we do the Monday after Thanksgiving. I think we'll get it in 4 weeks, clearly there. But I think that kind of schedule should give you a reasonable amount of time to get the work on the important work that you need to get done. But keeps this case on a little tighter schedule. It's going to be, as I said, I think the case was arraigned in April 27th of 2023. So I guess the suggested time that I'm giving you is 2.5 years. That seems like enough time. Now, I've said it a couple of times, I'm going to repeat it again, and I'll certainly hear you. You know the case better. When I see things in motions that say there's 27,000 pages of documents in this case, what does that really mean? I don't know, because I don't know what's in those 27,000 pages. Not all 27,000 pages are the same. You know what I'm talking about. And I don't know how much more is coming. But we can compare it to other cases tried here and certainly elsewhere in the Commonwealth and say at 2.5 years, it's time to go. And that's what I'm suggesting.
Ooh.
So I'll hear from both.
Got your
Who
marching
wants to go
orders.
first?
Well, Your Honor, I can say that as far as the discovery goes, it went in a couple different directions between the grand jury, which was about 1,000 pages, but I think it was a complicated case as far as pulling it together because there was a significant white-collar portion to it. So with that, I understood how the discovery got up to there in numbers, but that being said, Mr. Tipton and I have had a long-standing relationship and working on cases together against each other, and I think that we have a really strong relationship on trying to get to the heart of the issues. We talked about trying this case in 2025, and we were looking at potentially late October, and I'm looking at the calendar right now in front of me, and I think October 20th, 21st is the second to last week in October. To me, that gives us about a month before Thanksgiving, which is a nice target. I think it also makes it easier to get panel jurors. I think once you start crossing towards holidays, it becomes a little bit more problematic. So that would be my suggestion as far as the trial.
And just so you know, that's 6 weeks before Thanksgiving. Like Dave, you just picked.
October 20th is 6 weeks before Thanksgiving.
Yeah,
Late Thanksgiving.
Thanksgiving is again on late one, it's November 27th.
So that's, given the impalement being a long time, it could be like over 5 days, could be 7 days, I don't know. I think that gives us enough time.
After talking with the district attorney and our client,
Well, these speakers have got all
That
sorts
date
of
is good for
feedback
you, it's
happening.
good for me.
Mr. Rowe.
Do you want to look back or do you want to? This is that.
It's not mine.
Someone's media box has a phone or some device that's vibrating, so if we can shut that off, that'd be great.
I think it's stopped now on its own. All right.
Oh, that's what
Do
it
you want to work
was.
back?
Yes, we're going to work backwards right now. So what was the date that you just said?
So October 21st, Tuesday, October 21st.
I thought it was my volume booster. So there you go. It's going to be October.
if I could, Judge,
I just want to add, does anybody want me to ask Civil, do we want to start on the 20th?
Might be a good idea.
It's been a few years since I sat here, so it's, what is it? Monday is the civil
Monday's
day.
civil and
Tuesday and
Tuesday's
Thursdays.
criminal, but
It
exceptions.
wasn't that long, I guess it was about a year and a half ago. Just seriously.
Oh my God, I forgot to scroll.
All right.
Sorry.
Judge, if I could just, before we start nailing down
Dates, yes.
And just so you know, the Commonwealth, we all met and we hashed over a bunch of dates too, hoping that the court will find those dates agreeable. But having said that, briefly, I'm just going to say this: I didn't have the case for David.
I know, you came on board about a year ago,
I
right?
was in the middle of a double homicide when the case came up, and I really didn't look at anything for a few months.
Oh, really?
And when I say 27,000 pages, that's
I haven't even been watching that trial.
And included in some of that is video surveillance, hours of video surveillance. There's also transcripts of statements that still need to be properly transcribed in some instances. But aside from that, the forensic testing in this case
Thank you for mentioning that.
is extremely
What are you saying, Phoebe?
complicated.
He's
And,
photoshopped.
it's still ongoing. And the Commonwealth and I, and Attorney Porges, we're trying to work out an issue with the DNA testing and the exhaustive testing that is a very critical aspect of this case, and we expect to be able to, file a motion to address the issues we have. But the short story, judges, I hope the court understands. When we selected the dates for the proposed scheduling order, that was after we met a number of times. We talked about what the case was, our understanding of the case, and I want the court to know that we didn't suggest dates as a subterfuge to suggest, we'll just pick this.
And I don't think that anything I said in substance, or certainly in my intent, sometimes it gets lost in my translation and my delivery, was meant to suggest that that wasn't in the realm of possibility. I just think that it's probably not the best thing for the case. And I'm going to be here to try the case, whether it's in October or it's in April. But it's going to be tried in an efficient manner, and there's a reasonable view to, it's my pet peeve. I don't like serial motions to suppress. It's just as simple as that. But some people like serial motions to suppress. You don't know who you're getting on the other side of the bench. Some people like to take it in smaller tranches. I'm just telling you that I think there's a way to be more efficient. Of course, I'm not going to force or pressure anyone in this case within reason, and I'm never going to have to do it with counsel that I have here to make you do something that you're not comfortable going forward. I think we can be more efficient with the schedule, and I'm going to do my part to turn around the motions you do to present to me quickly.
And on the just now limiting to the issue of motions suppressing the dates, after the Commonwealth and I and Attorney Porges all talked, we think there is a need for 2 separate dates. And if we could, I would ask to come to sidebar to tell the court, to give you a reason that I'd like to do it sidebar.
All right?
Okay, that's enough of that.
And any jury instructions, proposed voir dire, I don't know if you're going to want to do a questionnaire. If you do want to do a questionnaire, you can reach out to the court. I have a couple of ones that I've used recently in homicide cases, and I can give those to you. It does, in some ways, make the impanelment, I don't know if it goes faster, but it raises issues in a more sensitive way.
I appreciate that, Judge. We've been working on a questionnaire already.
Okay, great.
I would appreciate anything the court.
I'm happy to share them. They're available, and I think that every time you look at a different questionnaire, different issues come to light that you think might apply to your case, so I'm constantly tinkering with it. But I'll share a few that I've had in the last couple of years.
Thanks. So, were you going to pick a date, give us a date for the filing of?
Everything's on that Friday before.
Okay.
Your Honor, if there are objections to anything that's filed on Friday, understand what it's written objection would be getting to.
You are muted.
Right. So what I was trying to build in was, and since I know that you work collaboratively, is I'd really like the whole package, like the 9A package, so to speak, together on that Friday before, so I can consider the objections, the oppositions. So if you can work collaboratively so that the oppositions are filed, maybe you give them to each other the week before. Your motions, if you want me to put that as a date, so initial motions to eliminate are the Friday before, any oppositions are the Friday before the 10th.
Objections by the 3rd.
Yep.
Final of the week before.
So the 28th of September would be,
Right. Yeah, you've got by September 26th. You'll file all
Thank you.
motions only when any objections or oppositions filed by the third.
That works for everybody?
Yes, Your Honor.
All right.
How dumb do you have to be
All right.
to have to Google how to murder someone?
Let's do, I think we
It's
agreed
pretty
to
funny.
1-2 on the motions to suppress.
I want to murder my wife. Here's a great idea. How about I Google how to do it?
Sure, thank you.
For the first motion to suppress, which we will believe, forgive me, will be evidentiary.
Yes,
We were suggesting April 7th. And then the following would be.
That's
for the
right,
remainder of the
Colleen.
motions to suppress May 12th. That would give council and myself 30 days to respond to anything that could come up.
okay.
Especially if you had a decision, would have time, the council would have time, or you would have time to examine it.
So, hold on a second, I just need to check something. Give a calendar for me.
Right, Prince. Even worse, right? First of all, like, Google's gonna give you answers. Like, hello.
Okay, 4/7 is a good date. That's on the evidentiary one.
Yes, Your Honor.
All right. I am not going to be here. I'm going to be close by, in that quarter as well. So just stay tuned for a location. But it's going to likely be.
God, I hope not. She's actually a decent judge.
147, right?
Yes.
Yeah. And that's 9 a.m.?
Yes.
Yeah.
And then 5/12. I can do that. I have to move something around, but I can do that. 9 a.m. also?
Yes, Your Honor. Also Middlesex?
Yes.
Thank you.
All
I
right.
think we've got all we're going to get from this.
Dates on the motion to dismiss.
So they've got trial date.
Just stay tuned for where that's going to be.
Oh, yes, Your Honor.
And this is all their motion hearings.
What
So
is going on with DNA testing? How long has the lab had it? What needs to be done? What has been done?
So the lab has tested samples from objects taken from garbage that was located outside the defendant's mother's apartment. It's also tested samples from inside the family home in Cohasset. What is at Bodie right now is tissue that was found on a saw in the garbage at the mother's apartment building. That can't be done by our state lab. Essentially, these items put in a wax paraffin block, and Bodie has the ability to take slices from the block and do DNA testing from that. There are 6 samples that have the potential of having results. And so where we're at is that they have the potential of also being destructive testing at Bodie. And so that's where we're at as far as potential motion. Bodie has a different, and Mr. Tipping can probably speak to this better.
Bodie Labs,
There's a different
again.
policy and procedure for outside experts coming in and doing their testing. And also, there's a cost. And Mr. Tipping and I have been talking about the cost.
Exactly,
and
Colleen.
It has to get paid one way or the other. The question is, who's going to pay it? Is the government going to pay for all of it? And so we're trying to figure that out. That might be the subject of the motion.
Okay. Anything you want to add to that, Attorney?
So the money issue will be resolved. I mean, we want $20,000 just to have someone stand there and watch. However, the real issue for us is the observation and what Bodie requires and limits any observer to see as compared to the Mass State Police and some other ones. So we anticipate filing a motion. We discussed it with the Commonwealth, arguing that Bodie needs to at least change their protocols for this case, especially given the gravity of this evidence that's being examined. And we'll file a motion, and that's the two issues. The cost, which probably is not much to talk about. It's the other one that needs to be addressed.
Okay. When can we take that up?
I think we should probably. I think we can probably do it on that same January date.
Yeah.
On the 8th, because I don't think it's going to. I think I'll file something that's I can rest on the pleadings and we'll just do it.
All right, let's do it then.
Yes, Your Honor.
Two of you work together with regard to when it's going to be filed and give each other enough time, obviously, to propose.
Yes, Your Honor.
All right, any other dates we need to set?
The only other thing is a discovery date, but I guess maybe we should wait and see. I know there's two, at least, there's other production of discoveries coming. I think when we come back, on January 7th, we'll look at a realistic findings.
All right, that makes sense too, and I think you'll have the benefit of my ruling at that point and know what additional I think you ought to be producing.
Yes, Your Honor.
The addition of that motion, does that change the Zoom option for January 8th?
It doesn't in my mind. If you feel differently, let me know.
I don't think.
I was intending on being there, but I know...
You're welcome. You're always, all of you are always welcome, wherever we are. But if it becomes an issue that we would have to cancel the hearing versus doing it on Zoom, then it would be my strong preference to do it on Zoom. So you have that option. Just let the clerk know what you're doing. And obviously, it does create, obviously, some problems if defense counsel is on Zoom and the defendant had a number of issues with facility not putting them on, and then it gets delayed. And so sometimes if there's two counsel, one will come up and the other will be on Zoom. Just work to make sure that everybody's coordinated so we don't lose the date.
Yes,
Ever have the defendant transported to Middlesex and nobody's there for him. I'm sure that won't happen, but given that there's some moving parts, I'm going to just alert you to the prospect.
Now that you've said you're sure it won't happen,
All right. So I'll see you all on the 8th, but before we close, is there anything anyone else wants to raise?
Okay, it's done. So I just chat GPT what did Whitey Bulger do with the toothpaste. And let me share that screen. I didn't know this. I'm not sure that... I might have to watch the movie again. I watched the Johnny Depp movie, but I don't remember anything about the mouthwash. But anyway, he reportedly gargled mouthwash before meeting with associates or engaging in criminal activities, likely to eliminate any potential DNA evidence, such as saliva that could have been left behind on objects like glasses, cups, or other surfaces. So there you go. It's because he understood the forensic methods law enforcement might use to track him. So there you go. Interesting, right? I would never have guessed, and I had to look it up just to see what was reported about it. So relapsed on mouthwash. It messed her mind up. They broke my heart. She lost everything. It's sad. All right. He was in LTL's chat. I don't know. I think I've missed a few things because I was looking that up. No, apparently he was hiding his DNA. Cheryl. Hello, Cheryl. Thanks for joining us. Uh, no, we've got no news on Proctor yet. We don't know if he's been fired or not, but obviously it's Brian Walsh's attorney's documentation that Elf on the Shelf is using to say that he has been. So yeah, interesting. 20th of October it looks like the date is, but we'll get more information on that because this has only just happened today. But yeah, it's interesting. I think things are going to hot up with Proctor on this case. Like, as Scott says, whatever it is, it's going to help the defense here. But whatever it is probably going to help Karen Reid's defense as well. So it's kind of a two-edged sword, isn't it? Yeah. Yeah. I don't think Sean actually understands that staying on this hate train with Turtle Boy is actually going to take, well, I think he does understand it's going to take Karen down, but I think he's in denial because of his because his hatred has just infected his brain. He's definitely in denial that it is going to affect Karen if he gets his way with Turtle Boy. So oh no, that's funny. People come up with the best handles, like even yours, Karen. And I don't know. I think I got a feeling that I know who half of yous are. Like when you change your names, I can't actually see what your old names were. So I got a feeling I know who none your business is. Yeah, why won't she fire him? What do you reckon? What do you reckon the reason is, Scotty? You reckon it's because Meatball's still protecting him, or why do you think she hasn't just like gone out and gone, yep, you're a liability, boink? Joseph reckons because they need him on the bench. Police union, that could be it. No, we can't see your real IDs. Can't see stuff all, to be honest. Involved in too many cases, you reckon? Too much involved in too many cases? Kind of think you could be right there. Oh, that's a good point, Anne. He might too. Holidaying at the Cape at Auntie Bev's seaside cottage. Might be because they need him too many cases. That seems to be the common consensus. It's all right, Colleen. We all read Taiwanese fluently. Yeah, it's a two-edged sword. It's definitely gotten unbalanced, but you got to remember what the point of unions originally was. The point of the unions originally was to prevent slave labor and to force unified um, wage amounts, and like a lot of good things actually did come from unions, but you're probably right, they've turned into a bit of a cesspool over the years. Here in Australia, the unions turned into like the mob. Like they started out how all over the world, they started out really preventing slave labor and sweatshops and stuff. That's where they kind of started from, but they have actually turned into like mobsters now. So it's like a full protection racket now. So that's not really political. That's kind of fact, really. Real handles. No, not on the live stream, but definitely in the chat responses, yes. That's why it's difficult for me to match up who's who when I'm in the live stream, because I don't see your real ones in the live stream. That's right, Lady Di. It all got screwed up. Now they're just a bunch of mob bosses under a different name. Yeah, like I said, mob bosses. They just take your money and kick you in the ass. Sadly, that's probably the case. Sadly, it probably is the case, Colleen. I think the next step for unions is to get the poor countries to adopt it, the ones that actually do still have sweatshops, and the countries that have ironed out these laws that protect workers now. I think those countries no longer need them. So I think it never had a development phase. They never thought about, once we've got the unions and we got rid of the sweatshops, what do we do with it next? And I think the next step should have been, moving on to the poorer countries who still have slave labor and sweatshops is probably the smart answer there, but they didn't have a plan. Yeah. What's Kev saying? He rattled on night one about how great it was to be in his construction union. Only problem is he feels no one else deserves to be unionised. Rules for thee, but not for me. See, the teachers' union here, I think I think the teachers' union year has actually been a good thing. Like, it's helped to bring up their wages here. I haven't actually seen that one become like the cesspit mob stuff that you see in, I guess, police unions and wharf unions, the wharf workers union and stuff like that. We've got what's the one that we got here? It's out of control right now. It's can't think of the name of the one that's gotten itself out of control here. Is there any Aussies in the chat? If there is, they'll fill in that gap for you. The blank, blankety blanks. I'm not even sure that we're ever going to see it, Mary. Sorry, everything moved too quick and I missed it. I'm not even sure that we're ever going to see it. I reckon it's always going to be sealed. It's never going to be released, I reckon. Exactly, Libra. Planning? What's that? Right, Kevin. And that's the point that I was making. See, some of these unions have done great things, but there's places where they haven't. They've just turned into a cesspool of mob bosses. So yeah, only good thing in the long run is their benefits after they retire. Yeah, that's it. It's pretty much how it is. All right, guys. Well, I think we covered a lot of ground here. We got some news about Proctor, and clearly he's still not fired. Clearly he's going to be involved in the Walshe trial, like, a lot more yet. So we're yet to see how much more and what that entails. But I got a feeling that stuff that's going on in the Walshe trial is going to be beneficial to Karen's trial. So we'll be watching that. We might watch that court case unfold. Originally, I was going to follow that, what was it? There was another court case that Bev presided over, to do with that cop shooter. I just can't think of their names right now. I'm so bad with names, remembering who's who. But I was going to do that one just to see how Bev behaves in a different environment. But she really frustrates me. I actually can't watch her doing stuff. But I think I can handle the Walshe trial. Like, everyone seems pretty normal in the Walshe. Dare I say it, even the Commonwealth seems pretty normal in the Walshe trial. I'm not getting weird vibes out of that prosecutor. Like, obviously he's hiding the ball. I mean, they've all got their strategies, and it's not really strategies that I have. It's not that the Commonwealth has the strategy of hiding the ball, but thank you, Carrie. Yes, the Chestnut trial. It's not that I have an issue with them hiding the ball, although to a certain degree I'd have to say, yeah, you got to start saying it's an issue when it's exculpatory evidence and stuff like that. It's definitely an issue then, but they got their trial strategies. The defence has theirs, and there's certain balls that they would like to hide, which, this is part of the problem we got with Sean, with Elf on the Shelf, just doing crazy shit like he does. It's part of the trial strategy to hide, part of the ball, so that you've got some surprises at trial, and you can have, like, for example, you can have a strategy where the Commonwealth doesn't actually know your strategy, so they're not prepared enough to have experts, for example, all lined up to smash down, that particular thing that you're going to explore during trial. So those kind of things can actually help the defence. They can. It's those kind of things that can also help the Commonwealth. But the Commonwealth is definitely under a lot stricter obligations, especially with exculpatory evidence. So yeah, I do get the hiding the ball a little bit, and I'm not even annoyed that it's happening in the Walsh case. Maybe I should be. I don't know. I guess we just have to watch it and see what happens. Yeah, Carrie, I was curious too, but I just can't handle freaking watching it. I I can't stand listening to a voice in a microphone. Like she's always giving that microphone a great big yeah, we won't go there because I don't want to demonetize my stream today. But yeah, I think you know what I mean. A blowy. We'll just call it that. Yeah, I don't know what else to call him. I think Aiden gave me the idea of Elf on the Shelf because he had to name his elf. He had to get his kids to name his elf on the shelf, and it kind of stuck in my head after that. So, yes, Glory, the heavy size, exactly. Scotty says, I always like to read Scotty's comments about these things. Meatball's moving pieces around, none of which will be Proctor. The strategy is now to move forward without him. It's over for Proctor first, then maybe the entire DA's office, depends on the feds. I don't know how much weight to put on the feds. I feel like everything the feds were ever going to move on in the last 10 years, they've never done it. Like they've let me down so many times where I was like, yeah, the feds will sort that shit out, and then they just go, they either drop it altogether and you never hear anything about it, or they go in the completely opposite direction and you're like, holy crap, that doesn't solve anything. So yeah, that's it, Carrie. I think I'm happier to listen to this judge and these guys. Like, soon as buddy McLaughlin opens her mouth, though, I'm gonna want to kick it in. I don't think I can handle listening to her, but it doesn't look like she's taken a lead role in this. So, gobby, it's a gobby. I won't get monetized for that goldfish. Demonetized, sorry. Hmm. Yeah, Shari, absolutely. It's not going to be happy thoughts at all if he screws everything. Um, Suzanne's the name. I don't know what you're talking about. Sorry, you lost me. Something must have been said that I missed. Are you talking about Joseph's comment? I think it's next year. Is it 2025, Scotty? I think it's like I think it's next year, or it might be actually 2026. Yeah, I'm not following that conversation. Prince, no idea what you're talking about. I am not in faith of the feds either, but Matthew Farwell's arrest. Yeah, I don't know. It could be a little bit of false security. But I hear ya. It did. Matthew Farwell's definite arrest definitely lifted everybody's hopes. Let's just say that. Yeah, that's what I thought. End of 2026. So yeah. Yeah. So yeah, I don't know. I kind of like Levy. Well, it's not often like I probably have about two cops and three or four judges that I really, really like. And then that's it. It's not often I'll go with anybody in the feds or the upper government that actually impressed me. But I think Levy actually has. Like he's going hardcore. Like the stuff that the arrests, the 50 different officers, like he's coming down hard on the MSP. And I do like that about him. So hang on. Boston 10. Over the months, there have been continuous calls for Morrissey to step down as district attorney, and now two people are vying. Yes. God, I hope the two people can get the votes, whoever it is. I did see one of them. I think I saw a video, one of them that's going up, and she seems like really competent. So I don't know that Morrissey ever actually has ever tried a case. But I know that one of the women who's going to run against him has. I know she's been, I think, a assistant district attorney or something like that. I know someone's going to correct me, but I know she's actually um, prosecuted cases. So yeah, people are worried that Trump's not going to want him because he's a Democrat. But I think Trump will actually look at his work history, like all these recent arrests. I think Levy's fine. I don't think. I don't know. This might be just because I don't live in America and don't know enough about the situation, but I kind of feel like he'll be fair about it. Am I going to put people offside saying that? Like, I don't believe the media that he's like the big a hole that they say he is. Kevin, I can't believe that he is going to be there 2 more years. Yeah, it's depressing. Yeah, well, when you control like so much of um the money that's involved um in the election of the DA, when you control all of that, that's what makes him powerful. I don't know that he's actually got the votes. I think he's just got the money. Like he has all of the what do you call it? He has them all in his pocket, basically. Like the lobbyists, the big lobbyists are all in his pocket. Yeah, I reckon he has too. Like, hopefully, I'm being balanced here by going a little bit, Democrat pro Levy, and then a little bit like the other side, a bit pro Trump. So I don't want people biting my head off because I really don't get into your politics, so I might not even know what the hell I'm talking about. Let's say that. So McClellan says, whoops, hang on. McClellan says he's been practicing for 20 years. He says he's upset with how Reed and Sandra Birchmore cases were handled by her. How do I know McClellan? I know that for some reason. It might be just because he's running and I've looked him up, actually. And Juna Perkins, yes. Now, that's who I 30 years experience as prosecutor and litigator. That's who I was talking about. So thank you, Kevin. Yes, exactly. That's part of the lobbyist group, right? The propaganda machine that MSM has become. Like, because they got the things that they want, that they'll tell him, we'll support you if you do this for mainstream media. you know, ban all the social media so that we don't get put out of business, for example. Yeah, there's war chess as well. Absolutely. All right, guys. I don't want to keep talking about politics. I'm going to get myself in deep water that I don't want to. It's too hot in America to talk about politics. It's a lot cooler in Australia. You can have like a basic opinion and then back out. Like Homer in the bushes. You can't do that in America. Once you're in the weeds, it gets too hot. So. Yes, I agree with you there, Prince Lover. I actually think there's going to be some dirty tricks going on. They all play dirty, them ones. For sure. Okay, guys. Well, that's it. I'm out. Thanks for joining me. It was a good little live stream. Had a bit of fun. Oh yeah, I want to do a live stream and chuck a link in the chat and get you all to or whoever wants to, like a call in, except I can't work a Google phone because we're banned from it here in Australia apparently. So yeah, I might just chuck out a link, and whoever wants to come up and have a chat, we might do something like that next live stream if you are interested. And I think a couple of you are actually used to being on screen. Wait, you won't lose your wrench here. You're house guest now, so you just got the wrench by default because you're a house wrench. A house wrench. You're a house wench. God, I'm tired. I didn't mean that. Right, I agree with you. It shouldn't be placed. It shouldn't be. So yeah, some of you have been on screen before and some of you haven't. So because I don't turn my camera on, it should make, some of you a little bit more comfortable coming up and having a yak. You don't have to turn your camera on because I don't. So, but anyway, we'll do that next live stream. And hopefully Abby will be back. So the house wench. Hopefully Abby will be back shortly. Like she apparently she went to the races in Florida, the car races, and then caught COVID, so she's been quite sick. That's why we haven't heard from Abby. She's been under the weather. So when she gets back, we'll definitely do. What have I got? Oh, I know. I got a battery warning. Shit. That's it. We're out of here, guys. You're a house wench, Tiff. Oh my god. That was just because I was tired. Yeah, Abby will be back very soon. So I'll tell her that you're all missing her. But I don't know how well she is this week, so I can't make any promises as to when. But she'll be back soon. All right, guys. I'm out. Be good.